The room clock says 10 o'clock, so we'll go ahead and get started. Although are the two clocks different? No, maybe they're the same. I'm pretty sure that's true. All right, I would like to open up the work session on SB 71. Appreciate everybody being here. I would like to start the meeting by just logging my complaint that this really shouldn't be with us, as much as I'm always happy to see the firefighters. The content of this bill isn't things that we usually cover or are well versed in. It's really more of an insurance issue for the most part, or Health and Human Services potentially, or labor. I mean, there's pretty much everybody but us. I don't know how we landed with it, but we'll do our best with it because we're certainly not subject experts in this particular area. So we'll be looking at the two sections of this bill. The first part having to do with the presumption of cancer and expanding that in RSA 281, and then the new section on a commission to study the implementation of optional annual cancer screenings. Did either of you guys want to say anything before I call anybody up to talk to us? No? Mr. Rell, did you want to join us?
Thank you, Mr. Chair, representatives. Brian Rill for the record, president of the Professional Firefighters of New Hampshire. This was
Ryan, could you just get a little bit closer?
Sure,
to the mic?
yeah.
Thanks.
This was something that we had constructed to try and get rid of a little bit of ambiguity in the current RSA, and really just a cleanup of the current bill, at least the first portion of this, and we can talk a little bit about, depending on how you want to do things here, a little bit about why we think it's ambiguous and a little bit confusing under current law and what we're looking to change.
Yeah, I think let's start with section 1.
Sure.
And the idea of presumption of cancer. I think that language, once again, we don't hear this language frequently in our committee, so I'd like some clarity on that and
Sure.
how you guys interpret it at the very least. And I know that you've brought Mr. O'Connor in as well to speak to that issue. So
Yeah,
be
if
happy
you
to
wouldn't
hear.
mind if
He
I
can
brought
join
him
you,
up?
that'd be
Okay,
great.
So, yes.
Good morning.
Morning. Mr. Chairman, representatives, just to give a little background, my name is Jared O'Connor. I'm with the firm of Shaheen and Gordon, and I've been practicing in the area of workers' compensation for about 20 years. It's really the sole focus of my practice, representing injured workers. I'm also on the Governor's Commission to establish a review presumption for PTSD in firefighters, which I've now been on for about 3 years. As well as the Commission for the Compensation Appeals Advisory Board that reviews the appointments to the Compensation Appeals Board, which is the body that hears appeals from Department of Labor hearings. So just a bit of background on my experience. So I thought I'd make myself available at Brian's request to answer any questions you have about how presumptions work or how this particular presumption operates in the course of litigation at the Labor Department.
Yeah, that second part, if you could speak to that, I think would be helpful to us, how presumption works in the appeal process.
Sure. So I guess I'd begin by way of background. In the absence of a presumption, which is how every workers' comp case works, it's always the claimant's burden of proof to establish that a condition is work-related, that the injury arose out of a risk that they're exposed to on the job. So it's, as the claimant's attorney, it's our burden to bring forward that medical evidence to show that, in fact, exposure to such and such chemical, such and such carcinogen is what, well, not carcinogen, but, in the normal workers' comp case, you have to show that the exposure to risk on the job is what caused this injury, and then bring medical evidence to prove that. What a presumption does, what both the PTSD presumption that has been passed into law and any other kind of presumption, if it's a rebuttable presumption, as this is, the idea is that it flips the burden of proof. So you walk into a hearing or into any case with the presumption that this injury is work-related. So that's where the hearing officer who's hearing the case is going to begin from that premise, that this is a work-related injury unless it's proven otherwise. That's the difference. And so the burden of proof of who has to establish this or who has to fight against it is shifted from the claimant which is normally us, to prove that it's related. It shifts that burden to the insurance carrier to prove that it's not, which might sound more significant than it is. I mean, at the end of the day, the standard of proof in these workers' comp cases is a preponderance of evidence. It's more likely than not. So when we're trying to win a case from the claimant side, we have to bring in medical evidence to show it's more likely that this injury is work-related than not. What a presumption does, what this presumption would do, is just flip that burden so that now it's on the insurance carrier to prove that it's more likely not work-related, which is a fairly common and frankly easy thing to do from their perspective. You know, I guess if you're looking more broadly at how the cancer presumption has worked in practice and how this would work in its expanded form, I guess I would say the expansion is not that significant in that you already have certain gatekeeping functions in the statute as to who can even qualify for the presumption in the first place. If you look at the statute as it exists now, the call or fire or volunteer firefighter has to show that they were cancer-free at the time of hire. The cancer as it exists under current law has to be a kind that's recognized by the IARC, the international body that reviews cancer. And there has to be 10 years of service. The employer has to have met certain guidelines with regard to following fire standards and training curriculum for best practices. You have to meet all of these before you even qualify for the presumption in the first place. What this expansion would do is basically expand it from the limited number of cancers that are presumed work-related now by the IARC to all cancers. So as long as those other conditions are met, then if the firefighter has cancer, then you can make the claim that this is work-related. The carrier at that point has every opportunity to deny the claim and then review the medical records and determine that, well, actually, no, you have a medical history, you're a remote smoker, whatever the other issues are. And if they have medical evidence to show that this is not work-related, then the claim is over at that point.
So for clarification, if this language were to not go through,
Yeah.
could a firefighter still bring a claim for other cancers? They just wouldn't come with presumption on their side?
Yeah, that's exactly right.
Okay, so we're not really expanding what they can make a claim for, just who bears the burden of proof.
That's exactly right. Yeah, anybody can make a claim for anything under current law. The question is, I mean, even with current cancers, you may not enjoy the benefit of the presumption because the cancer you currently have may not fall within the list of the IARC. Doesn't mean you can't file a workers' comp claim if you have medical evidence to prove that it's related. All the presumption does, the presumption is just a procedural mechanism. It just shifts, as you say, it shifts the burden of proof. So it makes it a little bit easier for injured workers to qualify. You can win just on the medical evidence. If the medical evidence is strongly against you, then you're not even going to win with a presumption. You know, you walk into that hearing and the medical evidence strongly points against this cancer being work-related. The fact that the presumption exists isn't particularly going to help because the other side, the carrier, the employer, is going to be able to show evidence all day long that this is actually a genetic condition that has nothing to do with work. You're still going to lose. What the presumption does is in the very narrow set of cases when the medical evidence is genuinely uncertain and it doesn't point in either way, either direction that strongly, in most workers' comp cases, tie goes to the employer. What the presumption does is that if there is really an equipoise there in terms of the medical evidence, tie goes to the claimant. And that kind of thing doesn't happen very often because generally speaking, the medical evidence is going to point more likely than not in one direction or the other.
Okay.
Representative, if I could too, just touch on something that Jared mentioned. While the benefit of presumption isn't necessarily a groundbreaking notion, right? We already have it. Many states already have much more robust presumption laws in place. And while it wouldn't change a lot of the procedures for filing a workers' comp claim at the labor board, What this does primarily for us in this moment is it shows a significant level of support from the state to its firefighters to say, look, we have your back. We want you to get the care and treatment you need. We don't want you to suffer financially because of that. And this is, I mean, we've received no opposition on this portion of it, either from the Senate or other stakeholders that want to oppose this legislation. And I think a lot of that has to do with the fact that there's significant medical evidence now that's showing us every day that we go to work, we're donning personal protective equipment that actually is littered with PFAS chemicals. And to do that to protect our communities is, we believe that the presumption is kind of a small, well, a large for us, a large show of support from the state side to say, look, we want you to have this benefit of presumption, but if your cancer is clearly not work related, it won't be covered as it currently is not covered.
So obviously this is workman's comp. This isn't health insurance, right? I mean, they're two different things. Would this have a potentially inverse impact on workman's comp rates if this were to pass? Do you see that having any impact whatsoever?
The impact that it could have would be a marginal increase in the amount of medical costs that the workers' comp insurance carrier is going to bear, and then therefore, rates to the employer. But so it's a question of how many cases end up being approved, and then the medical costs associated with that.
Mm-hmm.
And I guess what I would say is, just to sort of elaborate a little more on what Brian was saying, having been involved now on the PTSD Commission and the change in the law that we had there early last year, I want to speak to that for a minute because I think it helps. The analogy is basically equivalent. So PTSD in firefighters or in any employee had already been covered under workers' comp. If you have a mental stress claim in workers' comp, if you can prove that it's work-related, then it can be covered under comp. And what the commission was put together to study was whether there should be a presumption in this subset, this subclass of employees, that this condition is work-related. And the reason that it was approved and put into law is the theory behind a presumption, at least for PTSD, is that unlike other kinds of workers, firefighters, first responders, EMT, police, when they take a job, they are very likely to develop PTSD at some point in their career. It's sort of it comes with the territory. In a way that, for example, if you're a teacher or a 7-Eleven clerk, you're not likely to have PTSD in the course of your job. Now, you might get held up as a 7-Eleven clerk and then develop PTSD because of that one incident. And so if that happens, you have a perfectly valid workers' comp claim to say that you have now anxiety and stress because of what happened on the job. But it's rare, it's unusual, and it's not why you took the job. It doesn't come with the territory. With firefighters, police, EMT, corrections officers, that kind of mental stress and PTSD, it comes with the territory. You're signing up for that when you take the job. Like, it's likely to happen. And that's why the presumption was put in place. I would submit that the same kind of thing is happening with regard to cancer and firefighters. The evidence is beginning to show, and the IARC is developing a rubric to establish that the status of being a firefighter is an occupational risk for cancer. It's much more likely that you're going to develop cancer as a firefighter than you are in any other, maybe not any other, but in most other fields of occupation. And so that's the theory behind why a presumption makes sense. And in terms of the practical effect, which is essentially what you're asking, the PTSD presumption now having been in place for 2 years, what I've seen, at least in my own practice, so this is anecdotal, but it hasn't prevented insurance carriers from denying claims. I still have to litigate these cases from time to time. It's just, the easy cases are approved. The easy cases where it's clearly not work-related are denied and frankly don't get litigated. It's, again, these marginal cases when the evidence could kind of cut either way. In the case of a PTSD claimant, you've got someone who maybe has pre-existing experience in combat or childhood trauma or something like that, where there's evidence that suggests, well, they have PTSD, but is it work related or isn't it? And so you hash that out at the Labor Department. What the cancer presumption does is essentially the same thing. If there's evidence that cuts both ways, you go to the Labor Department, you have a hearing, both sides present their evidence, and you see what the result is. The effect of the presumption doesn't prevent either side from going through that due process at the Labor Department. What it ultimately does is, again, if the evidence is a close call on either side, then it can tilt in favor of the injured worker. But because that is such a small set of cases, I think that the practical effect, the financial impact on municipalities is not likely to be significantly greater over the long haul. It just makes the experience of having cancer as a firefighter, dealing with that and getting the treatment that you need a little bit easier.
To put it in a little
One
bit
second, Brian.
Oh,
sorry.
I'm sorry.
Do you guys have any questions, Chris?
Thank you, Mr. Chair, and
Yeah.
thank you for taking my question. It's been said before that we don't normally handle something like this in this, but that's okay, because I'm ignorant on all things, even the ones we do handle. The carrier, one of you gentlemen said, the carrier can deny the claim. Who's the carrier?
For most firefighters in the state, it's Primex. The city of Nashua and the city of Manchester are both self-insured. But for most other municipalities in the state, Primex tends to be the carrier that I see involved in these cases.
And when a workman's comp case goes there, are they going before New Hampshire Workman's Comp, or are they going before the carrier?
So the way this works is that when a claim is filed for a workers' comp injury, it's presented to that piece of paper that files the claim is presented to the Labor Department and to the employer's insurance carrier. So that piece of paper that says, I have a workers' comp claim or I'm claiming one, goes to the Labor Department and Primex. Primex then has 21 days to either accept the claim or deny it. If denied, then the claimant has a year and a half to challenge it by requesting a hearing at the Labor Department. So the initial brief investigation is done by the insurance carrier, but the hearing to actually present evidence, present expert reports, get testimony if necessary, that goes to the Labor Department. So a hearing is held here in Concord at the Labor Department with appeal rights thereafter.
I've only got 12 more
That was
questions.
great.
No, this is
That's
great.
less than usual. Go ahead, Chris.
So, if the carrier doesn't deny the claim, does it go to Labor Department Workman's Comp?
If the carrier accepts the claim, then there's no need to go to the Labor Department. Right, they just accept it and can pay. Although I should say, having accepted the claim doesn't mean that they're irrevocably bound to pay forever. They're always free at some point in the future to say, all right, well, we now question whether this remains related, and they have ongoing rights to challenge ongoing treatment if necessary.
Yep.
One
Go ahead,
more,
Chris.
one more.
Yep. No, you're fine.
So, on section 2, the notwithstanding part.
Yeah. That's, what is it, notwithstanding sections, notwithstanding
Wait,
section 216 and 27, yeah.
Right at the beginning?
Yep.
Yep. So, if this became law, if a firefighter claims a cancerous situation is caused by his job, whether it's on the list now,
Right.
it would be assumed that the cancer was job-related. And it seems like that makes the carrier or workman's comp hearing prove the negative. And I don't know how you prove the negative.
So, okay, that's essentially right. That's the point of a presumption, is that there's a prima facie presumption. Prima facie just means that in the first instance, we're going to assume this is work-related unless you can prove it's not. And so it does shift the burden of production, of producing evidence to Primex to then show that this cancer is not work-related. The way they do that, and the way they do that in the PTSD cases I'm involved with, for example, is they have the right, once a workers' comp claim is filed, to get the claimant's medical records, historical records having anything to do with the claimed injury. So they have a right to gather those records, to have those records reviewed by their own expert, and that expert can then say, because of whether other environmental exposures, because of your personal history, because of genetic history, that I can say, as Primex's expert, this is not, in fact, due to your exposure as a firefighter. It's due to obesity, smoking, whatever. And so they then present that to the Labor Department. The Labor Department has the authority to review those expert reports and say, this is more credible, the denial is upheld. Or not, depending on how the litigation goes.
Representative, if I could add to that, just recently we had a case in Dover of testicular cancer, which is a cancer that's currently covered under the IARC list. That claim was denied, and the subsequent review of it upheld the denial based on other factors. So they were able to, not only was the workers' comp carrier able to deny the claim, even though on its face it met every one of the benchmarks, upon further review they upheld the denial, and the member did not get the presumptive or the workers' comp coverage. So as Jared mentioned earlier, it is a fairly easy benchmark to reach in order to continue to deny these claims, whether or not the presumption's in place.
You can continue if you had something else. Brian.
Sure. Thank you. I just wanted to touch on, kind of expand upon the reason why the expansion makes sense to us. The current language refers to that it must be a cancer involved, must be a type which may be caused by exposure to heat, radiation, or a known carcinogen as defined by the International Agency for Research on Cancer. Now, when you go to look for that list of cancers that must be caused by exposure to heat, radiation, or a known carcinogen, and this was a link that I sent to all the committee members. The IARC has a monograph, a list. It's I believe 14 pages long of all types of cancers. There is nothing that specifically states exposure to heat, radiation, or a known carcinogen. And in fact, the language at the top of the form refers to carcinogens that are likely to occur in humans. And that's the entire list. So in 2018, when this legislation was passed, that was put in there to try and make some clarifications as to what was covered and what was not. To my knowledge, the intention was to cover the cancers on that list. And in turn, if you dissect it further, some have pulled out about 7 cancers that are actually covered from the IARC. But then if you look at previous reports from the IARC from 2010, there's at least an additional 8 that should be covered by this same organization. And they're not being covered right now, or at least under our presumptive legislation. So
Who interprets that?
So that would be a labor board decision, but I know that the researcher for the committee sent out an email that said these 7 cancers were covered, but you can search. I mean, there's articles from the IARC that I'll read it to you. 2010 report from the IARC considers there to be sufficient evidence for firefighter exposures causing the following types of cancers that are not listed in those 7. And it lists an additional 8 cancers. And further to that, the CDC cites an additional 9 cancers that are on neither one of those lists that firefighters are at increased risk for. So it's the list is not exhaustive of what we have increased exposure to, and that's what we're trying to figure out here. It's not, we're not trying to bamboozle the system and say we should be covered for everything. That's why there are all these other as Jared mentions, requirements to get through the gate in the first place. And then there's this review process that really determines whether or not we are eligible to receive the coverage.
Right. Okay. Any other questions, guys? Is anybody from the labor board here this morning? They don't seem to be too worried about it.
No, as I mentioned, I mean, this went through the Senate, ED&A 5-0, and it passed the Senate in quick fashion on a voice vote unanimously. There was no opposition in the Senate. I think, and I'm just speculating here, but I think realistically, just that case that I mentioned about the testicular cancer, really the requirements to refute a presumptive claim are not that difficult at the moment. So I think that maybe why there's not a ton of pushback on this.
Great. Is there anybody else in the room that's kind of a subject matter expert that can add something that hasn't been stated already? Okay. Oh, thank you, gentlemen. We may call you back in a bit.
Hi, my name is Christian Citarella. I'm the Chief Property and Casualty Actuary at the New Hampshire Insurance Department. Don't know if it's going to add anything, but it's just going to kind of support what Jared said regarding rates. So there was the question about how it might affect premiums. So 2 points to that. As Jared mentioned, if it does have an effect, it would certainly affect premiums on the increase, because the end result would likely be more claims, and then over time, those claims would affect rates. However, again, it is quite likely that the number of additional claims would be quite minimal in the grand scheme of workers' comp claims for firefighters. And don't forget, firefighters would only make up one part of the pool of folks that are insured through Primex. So Primex generally handles municipalities, and so it would be, I would expect it to be quite minimal. The other thing to mention is Primex is not regulated by our department. Primex is the pool that handles municipalities, and so that oversight goes through the Secretary of State's office and Labor Department. But just from an actuarial perspective, it would probably be quite minimal. The other thing that I'd like to ask a question about, or just have you keep in mind, the other portion of the bill that talks about the screening, that would be, Jared might know this as well, but from my perspective and looking at workers' comp, that would be unusual in a workers' comp system. And so there might be questions for Primex or carriers as to how that cost would be shared, and how that cost would be studied, and how that might affect premium. But that might be a question for
It would
the
be
commission.
for the
that doesn't
commission,
exist.
probably, if we form it. Yeah.
It doesn't exist yet.
And just for clarification for everybody, workman's comp claim in this scenario isn't more expensive than another kind of workman's comp claim necessarily, or is it?
You mean through Primex? Because
Yeah. So if somebody
it's
makes a
all-
cancer claim, it's the same as another kind of workman's
Right.
comp claim,
like
or it's
any
different?
other, what do they call it? Like work-related illness diagnosis, like carpal tunnel or something like that. Where it progresses over time, and there isn't one particular point, accident or incident, but that happens in all sorts of different occupations.
Okay, great. Thank you for that clarification. Any questions, guys? Yes, Representative True.
Thank you, Mr. Chair. I know you said that, in your opinion, the workman's comp rates may go up, or probably would, but it would be very small amount.
Yeah, it's impossible to tell. And again, this takes many, many years, because it's not as if, it is very unlikely that Primex would change their rates because of this change in the law. They would wait to see how the law affects claims, because there are kind of opposing forces here. There is the if there's that presumption, then there might be fewer arguments. There might be, fewer legal battles that go on because there are more claims that they know they're going to pay, and so they may save costs on defense or legal expenses, and that might get converted over to indemnity or medical payments. There's the other piece where if the commission over time ends up approving and recommending, and then we go into, the cancer screening, that could have the effect of reducing medical costs over time. And so you just, so yes, there might be more claims, but they might be less expensive. It's very difficult to tell how all those different variables will kind of work off each other.
Yep.
Yeah. Intuitively, yes, it would be more expensive, but
Well-
details will come with time.
So for Primex, you don't know how they're gonna react or what they're gonna say as a company or whatever, but they wouldn't say, oh my God, look, they just passed this law and now we have to jack up the rates to cover future costs. They would be more apt to say, over the course of 20 years, more cancers were covered under workman's comp, and therefore we're going to raise the rates?
Right. If I was Primex's actuary, I would recommend wait and see. Primex, as a pool, right? I mean, I don't know how that pool is structured. I mean, it isn't a for-profit organization, right? So they have a board. They answer to ultimately the Secretary of State's office. They need to justify their actions and their decisions and their rates to someone. My guess is that would wait and see. They would wait and see.
Thank you for
As a
that piece of
public good.
information. I didn't realize that Primex wasn't a for-profit organization. That's a helpful piece of information. Once again, not our subject matter most of the time, so we're learning a bunch of stuff as we go. Yeah, go ahead.
So that brings up 13 more questions. I'll keep it to one. So who is Primex? So Primex is all the municipalities in New Hampshire pooling their risk? Is that what Primex is?
Right. And Jared may know something about this as well. So
Feel free to
if-
join him too
yeah,
if it's helpful.
if you,
It's
so
very
I-
very laid
I
back
don't
in these things.
I don't know to what extent Primex is the hired adjuster and kind of the logistics service provider for the pool, or whether Primex is itself the pool.
That's
Yeah.
a great question.
And
I don't know the answer to that either. What he's referring to is like sometimes.
If you wouldn't mind speaking into
Oh,
the
I'm
mic, just
sorry.
because it's also recorded.
Sure, I'm
we
sorry.
can we can hear you, but they can't.
What he's referring to is that in some instances, like for example, like the city of Manchester and the city of Nashua are both self-insured for workers' comp, meaning they pay all of the costs of the workers' comp claims that come before them, but they don't themselves. Well, Nashua kind of does, but Manchester doesn't administer the claims. They hire what's called a third-party administrator to administer the claims and file the paperwork and keep track of medical bill denials and just handle the day-to-day operations of the workers' comp activity. But the checks that are actually written for people's weekly indemnity or disability benefits and all the medical benefits come from the city. So that's Manchester and Nashua. But for all other municipalities, it's Primex. And again, I don't know the answer whether Primex is just a third-party administrator. That I don't think they are. I think they are the insurer, and I think municipalities just pay the insurance premiums to Primex.
You're good, Representative Chair. Okay, great. Thank you, gentlemen. Do you guys want to hear anything else on the first section? Or are you comfortable moving to the second section, at least information gathering wise? Okay, great. So, Mr. Rill, if you want to join us again. walk us through the study commission, which there was one a few years ago, right? That's how we get the first presumptive language, but this one's going to be looking at something a little bit more broad.
So yes, apparently so. I wasn't around for that, but so the intent, and it's no accident.
Actually, if you can hang on for just a
Sure.
second, Steve, can you come up for a second then?
Sure, for the record, Representative Steve Pearson, Rockingham District 13, which encompasses dairy.
What was the primary focus of that study commission?
So that study commission occurred prior to me being a legislator. I was involved in the corrective. They did a language cleanup, like we like to call it. My first term, they missed something when they filed that first bit of presumptive language. The term before, my father was actually a co-sponsor of that. So they had as this body tends to do when we come up with a new concept, we have, what do we have? 300 commissions and committees that exist, right? So they looked at this as in generalities and kind of holistically, as my understanding, and then brought forward the legislation that we have, which currently definitely has holes and problems in it, right? So, and that's why this language is now before you guys again we'll call it a second revision to fix a couple of other things that came as a result of the 2018 or 2016 commission that happened, but I didn't sit on it. But that's my understanding, having been involved in the first language cleanup bill.
Okay.
Okay,
So
so
it might be beneficial to take a look at that and see if there's any useful information in it since it's already been done. Not saying that affects whether or not we do this one. I'm just saying it's out there and
So-
we have access to it.
Well,
so.
one of the things that's happening right now is twofold. One, the focus within the fire service on cancer has really just expanded dramatically as the revelations of things have come forward. That's part of it. The other thing that's happened, and it's in 2023, is for 200 years, firemen have been fighting fire and fighting cancer. But now women are entering this profession in numbers never seen before. So the kind of the baseline that we have of the concept of a common cancer amongst men is there. We're establishing those baselines based on historical data. What we have for women in this profession is nothing. So when you come up with a list of cancers under presumption to say, okay, these are the common things, we talk about testicular cancer. What we don't have in these presumptive lists is things that are specific to women. And that's why that's why this bill's idea of saying, look, let's not be solely restricted to a small list of things in an emerging field of study that has really only ever been studied in men. And that's why this particular legislation that passed the Senate can address the continuing changes that are ongoing and not having to continuously revisit every 2 years this type of legislation to add another cancer or another variant or another circumstance. You see what I'm saying?
Mm-hmm.
Because we get into the weeds. I mean, we all see the commercials on TV, type 17, non-Hodgkin, whatever. And you look at that and go, what the hell is that thing? Well, what if you're type 16 or 14 or whatever? And as a 27-year firefighter, I can tell you that there's 2 words that scare the hell out of us. One is layoff and 2 is cancer. So having to go through a battle and go through this process of having some sort of a weird list that has to constantly be changed and amended responsively instead of proactively is just another example of how government is just either too slow or just too behind things. And I think this takes care of that. And, obviously, as you heard from Attorney O'Connor, this is not in people's minds. when they define presumption or they define a process in their own head, as we've learned, that's really just not how it is. So I think that this is a truly important thing for that profession for the reasons I listed. And I think it would just be another situation where the legislature can just put an end to something.
Okay, thanks. Mr. Rowe, back to you.
Sure. So much like part one of this, in the expansion, the study commission portion of this, while it's progressive in nature, it's certainly not groundbreaking. Other states are doing these screenings now, and what I want to be clear about is this is not a commission to study whether or not screenings are appropriate or whether or not firefighters should be getting screened for cancer. We know that should be beneficial for all of us, right? What this commission would be tasked, hopefully, with doing would be determining how to implement a process and a program that would include things like what's the cost going to be to implement this program? Who's going to pay for it? Is there going to be a cost sharing? Is the state interested in that cost sharing? How much will the employee have to pay? What type of screenings are necessary? What other states are doing this now? Are the programs successful? Administratively, how would a program like this be put together? These are all things that we want to take a look at. New Jersey is already doing cancer screenings for firefighters. Massachusetts is already doing cancer screenings for firefighters. We actually have some local municipalities in the state now that are doing some form or another of cancer screenings for firefighters. In fact, there's, and I won't break the news early, but there's a community in our state that has worked with insurance providers and Dartmouth Hitchcock and is looking to implement cancer screenings for firefighters. This is not new stuff. It is progressive in nature, but it's not, like I said, oh my God, I can't believe that, we're going to be establishing a committee to look at doing cancer screenings for firefighters. It's already being done. So, rather than come in here and say, can we have $10 million or $100 million or however much money to say we want to implement skin cancer screenings, we want to do chest x-rays, we want to do CAT scans, we want to do whatever other cancer screening is available, and here's the cost to it, and being laughed out of the room. We'd rather do this purposefully and sit down and work with all of you and say, let's look at how a program like this could be implemented, and then bring it back to the legislature at a later date and say, can we implement it? So that's the purpose for part two. And it's no accident that these were placed together. As was mentioned earlier by the gentleman from the insurance agency, there could potentially be, however small, a slight increase in workers' compensation premiums over time. You've heard everybody testify here that if that happens, it's going to be minimal, but it could happen nonetheless. Now, this study commission portion is attached to it because we believe that if there are cancer screenings in place, early detection and early treatment are going to drive costs of treatment down. And so claims are going to be less in the long run. And that's how these programs have been so successful throughout other states, is that they've been able to get insurance companies, risk pool providers, medical providers, and municipalities on board with implementing something like this.
Thank you. Questions? Yeah, Steve, if you wouldn't mind letting Mr. O'Connor back up, that'd be great.
I just wanted to follow up on that last thing that Brian was saying, which is that what he just mentioned is exactly how it has worked with the PTSD presumption, which is that the law was changed to put the PTSD presumption into place, and the commission remains active in meeting on a monthly basis to review its effect, both on rates and on the community at large and how it's working in practice. And so Just thought that was worth noting, is that that's how that structure has worked with regard to the presumption for PTSD and first responders.
Great. Thank you so much. Thanks. Any further questions from the committee? Thank you, Mr. Roll. Appreciate it. Thoughts? Yeah. Representative True.
Thank you, Mr. Chair. So there's a commission doing this now?
No, there was a commission back in either 2016, 2018 that brought that original presumptive language that we're looking at into law. That was their recommendation. So we're not going to vote on anything today. We'll vote tomorrow morning when we have everybody here. Peter and Jason should be with us. So, but looking at the amendment that Representative True brought forward, how are you feeling about that amendment?
It's not ready for prime time.
Okay.
I don't think I'd have one ready for tomorrow.
Hmm.
I'd probably wait and see how the committee felt. If the committee wanted to go try to come up with an amendment that we all agreed with,
Mhm.
fine. But here's what I was attempting to do with my amendment. And granted, it's not right. I wanted to delete section 1, change the sunset date to November 1st, 2024.
So that they actually have some time to do it.
So, because that was mentioned
Yeah.
in our hearing, that 2023 was, even though it was worded wrong, wasn't enough time to do what work had to be done. Another change I made was to change the attorney appointed by the New Hampshire Association of Justice. My notes said Marissa Chase, representing the trial lawyers of New Hampshire, asked that they be replace that. So I put that in. However, and I gave everyone a copy of House Bill 1269 from last year. The way this commission is set up, the legislature is not the majority, and according to that law, the legislatures must be the majority of the commission.
Mhm.
So right now, and this is not a change, this is something I found after I got my amendment drafted. The most members a commission can have is 15, and 8 of those must be from the legislature. I think the general feeling was because we're the boss, and we should be the ones driving that car.
Right.
So that's another change that we'll.
So we'd have to
discuss
pull one other representative or one other member of the outside of the legislature off and replace it with a legislative member.
Yes. So,
Okay.
and then the question would be, who do you cut out?
Right.
That's why I didn't bother doing another one, because who am I to say? I'll leave that up to the sponsor or the committee to decide who's.
Okay. Fred, any thoughts? All right. Okay, why don't we recess this until tomorrow morning? We have another meeting in this room at 9 to look at this again. And I'll make sure that the other guys are going to be here for that. And in the meantime, I'll do a little bit more digging on the makeup of the commission and what that looks like. And we'll see if we can pull something together for tomorrow, because we're supposed to exec it tomorrow afternoon.
Oh,
Yeah, it's scheduled. I mean, I'm sure that Carol could recess it if she wants to, but we're scheduled for tomorrow.
because we're not going to wrap everything up tomorrow, right?
No, we have one more on the 23rd of May, I think. So there is one more work day. But sure. Any other thoughts?
Nope.
All right. I'll go ahead and recess the work session on SB 71 then until tomorrow morning at 9 a.m.